Tate Meagher with the Meagher Law Office. One of the frequent questions I get from someone that's been involved in a fall on a business premises is, ultimately, who is liable for my injuries as a result of my fall? Well, as attorney and as the business owner or the defendant, maybe in your case, or their insurance company, what we want to look at is and try to predict, what would a jury of strangers, what would they determine in your case? Who would they decide to be at fault for your fall? So in Kentucky, business owners for businesses that are open to the public have a duty to inspect for dangerous conditions that might cause someone to fall on the premises. If they breach this duty, they can be held liable. So if they aren't out there doing inspections, on a routine basis, and a dangerous condition, a crack in the floor, or at a grocery store, if milk is spilled on the floor, an hour passes by, it's not cleaned up, you go in there and you slip and fall. And no one inspected for that condition, that dangerous condition that caused your fall. The business can be held liable. Now, would a jury determine that they were liable due to their breach of this duty that they owed you as an invitee on the premises? That's ultimately what we're trying to determine. Now, Kentucky is known as comparative negligence state. Ultimately, what that means is that a plaintiff can recover for their damages even if they're at fault for their fall, so long as they're not determined to be 100% at fault for their fall. So, for instance, if a plaintiff goes into a store, falls on wet floor, there's a wet floor sign out, but it's way far, not even close to the spill. Maybe in that scenario, a jury says, hey, store, you should have put the slip and fall sign closer to where the actual danger was, closer to the wet floor. So a jury, because of that, you're going to be 50. We have determined that you're 50% at fault for the fall. The jury could also say the rest of the 50% of the fall is, hey, the plaintiff, goes on the plaintiff, because they should have seen the wet floor. Maybe it was like Coke, that was easy, not water or something, because Coke you should see on the floor. It's maybe open and obvious, so the plaintiff should have seen it. We're determined that they're going to be 50% at fault for the fall as well. So in that scenario, the plaintiff, the injured person that fell, can still recover for their damages, but they would recover 50% of their damages from the defendant, the store, or their insurance company. They would be out the other 50% that the jury determines that they were at fault for the incident. So that's just an example. Every case is different. I would highly encourage that you retain an attorney, consult with an attorney if you've been involved in a slip and fall or trip and fall on a business premises and have been injured as a result of that. Every case is different. Facts of every case are different. It's not an easy thing to do to predict a jury of strangers would do in any case, but an experienced attorney should be able to help you out to evaluate that case and let you know what your legal options are. So that's all I have for you today. Thanks for watching. I would encourage you to subscribe to my YouTube channel called Tate and watch more of my videos. Thanks.